Good morning. Around this time of year, we would obviously usually hope to be seeing you all in person at our conference. Happily in London today at least, and I hope it's the case in Guernsey as well. It is an absolutely blindingly beautifully hot day. I'd like to welcome you, hopefully in the sunshine where you are, to the first of two webinars that we at Wilberforce are hosting as lockdown continues. This webinar is focused around the often overlapping practice areas of insolvency, fraud and asset recovery. And we've entitled it Hard Walls and Ways Around Them. To start with, Clare and I are going to be discussing reflective loss with you, and then we're going to pause for a Q&A on that section, and then we'll move on to a second half where Lexa and Daniel are going to be talking to you about arbitration claims by and against insolvent companies, and we'll have a separate Q&A for them. So as I just alluded to, and as many of you will now be no doubt very familiar with from no doubt having attended a number of other webinars, there is a Q&A function at the bottom of your screen, and we're very grateful, and we'd very much like to encourage you to use that across the two talks. As I say, we'll pick those up at the end of each half. We'd be grateful if you could use the Q&A function rather than the chat function or the always endearing hands up button, just as it makes it a bit easier to make sure we don't miss you and we can answer all of your questions. And I think with that, we will move on to the first half, and that is me. So if I can move on to the next slide, that should then be just a cover slide for, there we go, perfect. So I put up on the screen, so we're all starting on the same page. It seems to me that the most pithy summary of the rule against the recovery of reflective loss, as I'm going to call it, as a matter of English law, is that of Lord Bingham, as it so often is in Johnson and Gore Wood, an authority we will be coming back to. And I've put the quote I have in mind up on the screen, and it reads, "The loss claimed appears to be or is one which would be made good if a company had enforced its full rights against the defendant." And if that sort of slightly unusual intonation jarred with you, it's because I want to highlight those words to you, because as we will see, there is quite a lot packed into that sentence. We'll come back to that over the next few slides. Now, this on its face rather technical sounding rule has taken on a life of its own. It appears to have an ever wider scope, ever narrower exceptions, and if you are caught by it, your claim is struck out. Given that the use and abuse of companies and their assets is a common feature of insolvency, fraud, and asset recovery claims, this rule has an obviously wide potential impact on claimants. And after all, if you have no cause of action, it's going to be rather more difficult to get any interim relief you might be after as part of your strategy, such as a freezing order. Now, if I can move on to my next slide again, I've set out there some of the very large number of decisions in this area in recent years. I don't propose to take you through all of those today. I'm not sure if that would be the most helpful way of introducing you to the topic anyway, and it would take far longer than an hour even just to get through those. What I propose to do instead is set out for you 5 points that I would submit are the key points to take away from the present state of English law. But it's slightly helpful just to have an initial sort of understanding of the legal landscape. There's only one decision of the House of Lords or Supreme Court on reflective loss. That's Johnson and Gore Wood back from 2001. Before that and since then, there are a large number of decisions of the English Court of Appeal, most recently Marex in 2018. These have been followed notably in a number of offshore jurisdictions, perhaps most notably Cayman, where two recent decisions of the Cayman Court of Appeal have followed that English case law and developed it significantly. It seems to me those decisions would be at least highly persuasive in England. There have also been a raft of first instance decisions, many of which could be read as attempts to get around the scope of the rule as it was defined in the Marex decision in the Court of Appeal. Marex was heard last year in 2019 in May by a panel of 7 justices, which is their default setting, as I understand it, when they are considering one of their own past decisions, a point which I'll come back to. This judgment seems to have taken them some time, and query whether at this juncture the English law rule will take a different turn. So if I can move on to my next slide, I'm going to start setting out some of these 5 key points, as I say. So first of all, the rule is a rule. There is, at least in theory, for our exceptions, as I shall come on to, no exercise of judicial discretion when it applies. The claim must be struck out. This comes most clearly from the speech of Lord Millett in Johnson, and was also the result in the Marex decision I've already mentioned a number of times, and that comes clearly from the judgment of the paragraph I've put up on the slide. Secondly, the rule applies to certain types of remedy, not, generally speaking, certain types of claim or causes of action. In other words, it applies to reflective loss. Now, this is clearest from the decision of Gardner and Parker, a decision of the English Court of Appeal a few years after Johnson and Galwood, where one of the very points on the appeal was, does the rule against reflective loss apply where you've got a claim for breach of fiduciary duty? And the answer from Lord Justice Neuberger, as he then was yes, it does. The rule applies even in those claims. And he set out the quote, the paragraph I've put up on the screen there. I mean, I put the reference on the screen, a passage that's become somewhat canonical where he makes clear that it applies to remedies, not claims or causes of action. Now, an interesting development in recent years that seems to have come out of this is a line of case law where it's been found that there was at least a good arguable case that the rule does not catch certain types of injunctive relief, so qua-timit injunctions or mandatory injunctions, or a claim where your remedy isn't damages, where you're seeking specific performance of a contract. And it seems to me crucially, where what's going to happen is the asset is going to be restored to the company. That's going to be the effect of the remedy you're seeking, and nothing is going to be paid to you, the claimant. And as I say, there's a number of cases in England and in Cayman where it's been found to be at least a good arguable case that that's right, and the rule doesn't bar those claims. So if I can move on to my next slide, my third point, the rule is not limited to shareholders claiming as shareholder. Now, this is what most people seem to think the rule is all about when it comes up. And that, after all, was the point in Prudential Assurance and Newman in the early 1980s when the English Court of Appeal first recognised the rule. However, that has not been the case since Johnson itself. Now, Johnson is one of those tremendously helpful decisions of the House of Lords where none of the law lords agreed with any other expressly on the reflective loss issue, save that Lord Gough agreed with Lord Millett. So there's quite a persuasive and a weighty plurality, but there is no majority speech on the reflective loss issue. Nonetheless, the result in Johnson, and most clearly from the speech of Lord Millett, makes Johnson authority that the rule includes a claim by a shareholder claiming on the basis of their rights as a creditor. In that case, they were an employee. Now, what I'm getting at here is that the guts of the claim that was being made by the claimant against the defendant was that the defendant's actions had caused the company to be unable to pay the claimant. So if the company was made whole, then the guts of the claimant's claim would be answered. And that's where the pithy quote I set out before comes in. That the rule extends to shareholders claiming as creditor was confirmed by the Gardner decision I've already mentioned, and Neuberger in Gardner also said obiter, that in his view it should extend to a creditor who was never a shareholder. He couldn't see why it wouldn't apply to both. And Lady Justice Arden had expressed the same view obiter in a second outing to the Court of Appeal in Johnson. And so that was the state of authorities that came before the English Court of Appeal in Marex, and it didn't take them a tremendous amount to come to the view that it did indeed extend to a claim by a creditor who was never a shareholder. And so one of the interesting things about the Supreme Court appeal is that, and this is perhaps why it's taken them some time, most of the options open to the Supreme Court, if they were trying to curtail the rule, would involve them revisiting Johnson quite significantly. And so it's not just a case of overturning one recent, potentially thought to be aberrant decision of the Court of Appeal. So moving on to my fourth point, the rationale behind the rule is said to be based on a number of policy considerations, and you often see these discussed in some detail in the cases considering the scope of the rule. There's authority for all of these across the speeches in Johnson. They're conveniently listed all in one place at paragraph 32 of Marex, and I've put the reference there up on the screen as well, which held that these policy considerations applied equally to a claim by a creditor who was not a shareholder, as they did to a claim by a shareholder. Now, the two of these that seem to me to be quite good ones, although query if they, this is the best way to achieve those policy considerations. Firstly, there's the policy of avoiding double recovery. And secondly, which is always to me slightly more of a bootstraps point, there's a causation argument that the real cause is that the company hasn't sued, and that's what's actually caused the problem. There's a third policy consideration that's set out in a lot of different ways in different judgments. It's never quite clear to me what is driving the bus here, but it said that there is a policy of encouraging settlements, that if you allowed claims by creditors or shareholders, it would create a risk of conflicts of interest between the different parties, and that might make it more difficult for a settlement to be achieved. And lastly, and it seems to me most persuasively, and it seems to me really actually two separate points, there is the need to preserve company autonomy, and there's the need to avoid prejudice to minority shareholders and other creditors. In other words, stop one creditor stealing a march on the others. Although you might say in response to that in some situations where you've got a well-funded particular creditor and you've got a particularly tenacious defendant, you might want one creditor to steal a march and save the day for everybody rather than let it all go and then become irrecoverable. And then if I can move on to my last slide, my fifth point is that the rule has only a few narrow exceptions. Now, in some ways, it seems to me that this is where we really see how wide a scope the rule now has. So firstly, you can bring a claim and the rule doesn't apply if the company itself has no cause of action. That was set up by Lord Bingham in his speech in Johnson, and that has been widely followed since. But this includes quite a bit more than you might think it might. So the exception doesn't apply and the rule does catch you where the company has settled its claim, even if it settled it very badly, and you might think, oh, we could have done much better than that. This is very frustrating. You're stuck. That doesn't allow you to get around the rule. Indeed, the rule still applies, and you're not in this exception, even where the company simply has never sued, right up to the point that its claim has become barred by a limitation defence. So the second exception is where the claimant is owed separate and distinct duties and has suffered separate and distinct loss. Now that sort of in theory makes a lot of sense. The cases in which it does and doesn't apply very much turn on their own facts, the particular causes of action relied upon, and I'm not sure if setting out examples here is as illustrative as it is on other points. This again comes from the speech of Lord Bingham and Johnson, which, as I say, has been widely followed. It seems to me that post-Marex, this is the line of attack that a lot of people seem to be taking. There's the UCP and Nectris case I put up on the earlier slide where I was listing out some of the recent cases. There, a claim pursuant to a three-party contract was exceeded and was found not to be caught by the rule. It also succeeded in the recent Zedra and Hutt case I also put up on the earlier slide, but it has failed in other recent cases such as Magdev and Zvetkov. I'm not sure if that did make it to the earlier slide, it might have. The third exception is perhaps the most interesting one, and that is the one that comes out of the decision of the Court of Appeal very shortly after the decision of the House of Lords in Johnson and Gore Wood of Giles and Rind. Now, this might loosely be described as a fraud exception. What if the defendant's wrongdoing left the company unable to claim? And yet, the way that it has been applied and defined in Marex suggests it is much, much narrower than that. There are two prongs to it, according to Marex. Firstly, the company has to have a claim. If the company didn't have a claim, you'd fall in the earlier exception we mentioned. But the company's claim has to be legally impossible. And so, for example, in Giles and Rind itself, there had been a settlement agreement in which had compromised the claim or involved an undertaking whereby the company could no longer bring the claim. And secondly, the defendant's wrongdoing has to have directly caused that state of affairs. Now, that seems to me to pose a really very high test. It was met in Giles and Rind itself on those facts. It was also met in another decision at first instance of Perry and Day, and a very, very recent case of Kalakis in the commercial court held there was at least a good arguable case to go to trial on Giles and Rind. I should say that there have been suggestions in some other cases that there are other requirements. There's a case of St Vincent and Robinson in which Clare appeared as counsel, which asked whether, queried whether there was a third requirement of the defendant intended that state of affairs. Mr Justice Mayles, as he then was, though went on in his judgment to note that that wasn't there in the judgment or the reasoning of Gardner and Parker, that other English Court of Appeal decision I've mentioned, and Marex hasn't picked that up, so it seems that isn't a third requirement, it's just those two. So just to very briefly recap, the five the 5 submissions, the 5 points I'd say come out of this recent line of case law is the rule is a rule. It applies to certain types of remedy rather than claims or causes of action. It applies to more than just claims by shareholder claiming as shareholder. It's all about where the guts of your claim is made good, if the company's made good. It's rooted in a number of policy considerations, and you'll want to be familiar with those when arguing whether the rule applies or not, as they seem to come up in almost all the cases. And fifthly, it does have a number of exceptions, but those are themselves very narrow. And so with all of that, and given the difficulties that throws in the face of a claimant in a fraud or an insolvency case, you might ask whether a sense of wider perspective has been lost. And with that introduction to the position as it stands in England, which I hope will be an illuminating contrast to what Clare has to say, Clare is now going to take you through the position in Guernsey.
Yes, hello. I'm very impressed that you've all managed to log on today, because if the weather in Guernsey is anything like it is in England, I have to say I'd rather be upstairs in my bed covered in a cold wet towel than sitting in front of a computer listening to a talk about reflective loss. But thank you for coming. I'm going to talk about the position in Guernsey. It's different in at least one respect to that which applies in England and indeed in Cayman. And it all stems from, as you would expect, the trust dispute. The case of Jefcoate and Spread Trustee. I don't know if anyone who was in that case is online today. It would be very good if you could participate and tell me where I've got my analysis of it wrong. It's a case which was heard in 2014 in front of the Lieutenant Bailiff Hazel Marshall, and it was a case in which a beneficiary of a discretionary trust sued the directors of the underlying holding company, which owned a piece of land, and also sued the trustee of the trust. And the claim was, in brief, that the land was sold at an undervalue and that there was a gross breach of duty. A conspiracy claim was also floated but dismissed in very trenchant terms. The claim by the beneficiary against the directors failed because no separate duty was owed to the beneficiary, which is obvious, and the beneficiary hadn't, as it had foreshadowed, brought a derivative action. So the claim against the directors was forlorn. They weren't found liable, and so in those circumstances, you might think that the rule against reflective loss isn't something which would necessarily be engaged, because the trustee, Spread Trustee Limited, wasn't a director of the underlying company. So there was going to be no identity of a defendant, and therefore no risk of double liability of Spread Trustee to the underlying company and to the beneficiaries. And given that is, I think, the major policy reason for the rule against reflective loss, I'm not sure that it was actually anything to the point in this case, but it was argued. I suppose it could have been the case that, and Hazel Marshall refers to this in her judgment, that the trustee could have been a shadow director of the underlying company and thus exposed to a claim by the company against it or the sale at an undervalue. And then, of course, the trustee would be exposed to double liability, one liability to the company in respect of the value of the undervalue, and also to the beneficiaries in respect of the diminution in value of the shares in the underlying company. But the shadow director argument wasn't run, and so the rule against reflective loss, I think, should have fallen away at first base. In addition, I think another point which could have been argued, and I think is often a way around reflective loss in a trust context, is that the directors of the underlying company, in selling the land at the value that they did, acted with shareholder consent. So in this case, there was a structure, number of other companies interposed between the underlying company and the trustee. And the reality is, in these structures, that decisions made by the directors are decisions which are approved by the companies above it in the structure, and almost inexorably approved by the trustee, in which case the directors would not be liable because of the in England, the rule in multinational gas that shareholder consent to what the directors have done amounts to an absolute defence to a claim in negligence. But you should never let the facts get in the way of a good opportunity to say something about the reflective loss rule. And that opportunity was taken in the spread trustee case. And Lieutenant Bailiff said a number of very interesting things about the rule against reflective loss. First of all, she said that but for the authorities in England on reflective loss, and so as a matter of principle, if there wasn't a rule against reflective loss, she saw no good reason for barring a beneficiary from suing a trustee for breach of a different kind of duty to the duty that the directors owe to the company. In that way, she would say, leaving authority to one side, you should look at the nature of the duties owed rather than the nature of the loss claimed. But of course, that's as the rule against reflective loss has developed in England and Wales, you are just focusing on the loss, and the cause of action is largely irrelevant. But she then did move on to consider the fact that there are these authorities on reflective loss, and proceeding on the assumption that the rule did apply and extend to those claims against directors. She rejected the English approach, and the reason she rejected the English approach, and I think with good reason, is that the English approach is dictated by English public policy. So the rule against reflective loss is an exclusionary rule. It's a rule about English public policy that defendants shouldn't be exposed to double liability, that a claimant shouldn't be able to recover twice through two different routes, and the other policies that Jamie has identified. Guernsey public policy, she said, was different. She said she was free, and of course she was, because she was unconstrained by the English authorities. Guernsey must look at the practical consequences. So whilst the rule against reflective loss may apply in Guernsey, in a case where the company has no practical possibility of bringing a claim, or there is no realistic prospect of double liability or double recovery, then the rule has no application at all. So it's a massive extension in practice of the rule in Giles and Ride. And in Jefcoate and Spread Trustees itself, that she thought there was no practical possibility of double recovery or double liability. First of all, the underlying company had been struck off. Secondly, even if it could be restored to the register, it wasn't insolvent. So there wasn't a concern about shareholders scooping the pool at the expense of creditors, which is a good sound policy reason for the rule against reflective loss. The third reason was that the possibility of restoring the company, resuscitating it, and then bringing a claim against the trustee was vanishingly small. So she again was looking at the practical possibility of the trustee facing a duplicative claim further down the line. And then she said, even if it did bring a claim, even if someone did bring a claim against the trustee, she thought, and this is where I part company from her, that some order could be fashioned in those new proceedings to prevent unjust double recovery against the trustee. And I, for one, am struggling to understand how that would be the case. So, for example, say the company was restored to the register and then it was sold to an independent third party and the claim wasn't statute barred. That independent third party could sue the directors, sue spread trustee as the shadow director, and the beneficiary wouldn't be recovering doubly, but STC would be exposed to double liability. So I'm just not sure how that works. But then finally, she expressed the view that there was much to be said for the Jersey approach identified by Sir Michael Burton, Freeman and Ansbacher, that the reflective loss rule shouldn't apply at all when it involves a claim by a beneficiary against a trustee for reconstitution of the trust fund. And again, I'm not sure that you need to express it in those wide terms. You can always evaluate cases, not by reference to sort of vague public policy notions and whether or not it's right or wrong for Jersey or Guernsey as an international trust centre not to have a rule against reflective loss. But in a case where there is a trust structure and there has been negligence at a level low down in the structure, and the directors haven't been sued, the way to sue the trustee is when the claims against the directors have become statute barred, you sue the trustees for not suing the directors. Reflective loss doesn't come into it at all because there is no claim against the directors, and there is a separate new loss caused by the trustees' wrongdoing. So that is where I see probably it taking rather longer than I ought to. Where the position is in Guernsey, it's much more of a free-for-all, I think. And I think you're going to have a lot of fun on reflective loss, whatever happens in Marex and the Supreme Court. Right, we don't have any Q&As. Do you think that means, Jamie, that we've written some kind of thesis and explained it all so well that no one has any questions?
Well, I wonder if people just want a little bit of time to digest. And I mean, another option is that we move on to the second half. And if anyone has any questions they want to ask, we do a joint Q&A at the end. And equally, if anything occurs to you a little bit later, please do feel free to email either of Claire or I, or ideally both of us, and we can chip in with any thoughts that we have. But I think in the circumstances, we will move on to the second half and to Lexa and Daniel, who are going to be talking to you about arbitration claims by and against insolvent companies. And Claire and I will turn off our cameras here so you can have a better look at the two of them. And I'll reappear at the end just to run the Q&A if you have any questions for them, or indeed for Claire and I, as I just mentioned.
Hello everyone. So I'm Lexa Hilliard, and I'm going to be talking with Dan Lewis about arbitration claims by and against insolvent companies. For those of you who don't know Dan Lewis, I'm delighted to say that he's recently joined Chambers. He's a senior junior, and his experience, well, lies everywhere really, but especially in insolvency and company law. So as an insolvency and company law practitioner myself, I'm absolutely thrilled that we're just adding to our team. Anyway, if we can just move on now to the outline. I just want to outline briefly what we're going to address you on today, because arbitration and insolvency, it's like sort of two huge jurisdictions that diverge extraordinarily, and it's very difficult to marry the two up. And there hasn't really been that much discussion in case law, that many cases where the difference between the two has been discussed in any great detail. what we're going to do today is we're going to present the presentation in 3 stages. Stage 1, we're going to deal with a situation where you've got petitions to wind up and where the alleged debt is due under a contract with an arbitration clause. Then stage 2, we're going to discuss the situation where when a company is in winding up proceedings or in administration, and there are arbitral proceedings already on foot at the time that the company goes into liquidation or administration. And then the 3rd stage is where you have a liquidation or administration already on foot, and there's an issue about whether or not to commence arbitral proceedings. And that particularly comes up in the context of where creditors are seeking to prove their debt. So if we can I'd just like to move on now to the next slide, which is dealing with stage 1 and the tension between the 2 tests that have arisen in connection with a situation where you have an arbitration clause. As I'm sure most of you are aware, that where a petition or an application is made to wind up a company, then what normally happens is that the court considers whether the debt that is being claimed is disputed in good faith and on substantial grounds. That's the second example. So the normal situation where you have an application to wind up, that's the test that the court applies to determine whether the petition or application to wind up is well-founded. And if the court finds that the debt is not disputed in good faith and on substantial grounds, then there'll be no winding up order being made. However, where you have a valid arbitration agreement, the general consensus, although it's not overwhelming, but the general consensus appears to be that the test is different. The test is a sort of prima facie standard of review, which Dan's going to be talking about in a minute. So you have a look, first of all, whether there is a valid arbitration agreement between the parties. And secondly, you have to look at whether the dispute falls within the scope of the arbitration agreement. If that is the case, then the standard of review is likely to be different. So now Dan's going to address you on these different standards of review, which I think is really dancing on the head of a pin, but the courts take it very seriously. So can we have the next slide, please?
Thank you. Thanks, Lexa, and thank you for the very generous introduction as well. I'm red because my office is incredibly hot, but I'm also blushing as well. What I'm going to look at, as Lexa says, is the evolution really of the test that she outlined and how that's played out in the recent authorities, because what you're presented with really is 2 alternatives which appear pretty stark as to whether or not the court can or cannot look at the underlying merits of the case where there's an arbitration clause. And the leading case in the area is still the decision of the Court of Appeal in 2015 in Salford Estates and Altomart. And the facts in that case are pretty common for cases of this nature. The lesser claimed service charges and insurance rent, and those claims were subject to an arbitration clause. The claims were submitted to arbitration and an award was obtained, but further charges fell due after that award was given. The lesser presented a petition to wind up the debtor company, including not only the arbitration award, but also the further charges that had accrued after the award had been given. And the company offered to pay the arbitration award sum, but applied to strike out the petition in respect of the further charges for which there was no award. And from those facts, it might be thought pretty obvious that there was very limited, if any, merit to the grounds on which the debtor company was disputing the debt. In fact, the debtor company basically conceded as much, submitting that even if the court concluded that there was no real dispute as to the debt, it should nonetheless stay the petition automatically. The creditor submitted that the winding up petitions, by their very nature, they're not an adjudication of a claim. The court, when it hears a winding up petition, isn't deciding a dispute. it's dealing with a class remedy in the public interest for creditors as a whole, and that the statutory power to consider whether or not a company should be wound up was reserved to the Companies Court, regardless of whether or not there was an arbitration clause. And in so doing, the Companies Court always had a discretion as to whether or not a company should be wound up, all of which seems to make perfect sense. However, the Court of Appeal did not agree. The decision really is significant for three reasons. As to the question of the jurisdiction that was being exercised by the court when it decided whether or not to restrain presentation or dismiss a winding up petition, the Court of Appeal said that it wasn't the discretion under Section 9 of the Arbitration Act, which provides for an automatic mandatory stay. In fact, the Court of Appeal accepted that the jurisdiction was discretionary, and it was the jurisdiction that the Companies Court always has in relation to the petitions that appear before it. However, while accepting that there was that discretion, the Court of Appeal said that it should apply the policy behind Section 9 of the Arbitration Act, and that meant that the parties were to be held to their agreement, i.e. if they'd agreed to arbitrate, that's precisely what they had to do. And it also meant that the court wasn't permitted to look at the underlying merits of the claim. If it was allowed to do that, the Court of Appeal said that was something that was open to abuse, and a party could force argument of the merits in open court by pursuing winding up proceedings rather than going down the contractually agreed dispute resolution procedure. And thirdly, the Court of Appeal admitted the possibility, at least, of considering exceptional circumstances and potentially the underlying merits of the claim. It said that it might disapply the legislative policy behind the 1996 Act if there were, quote, wholly exceptional circumstances, which, as it said, is very difficult to envisage, and no examples were given to help actually ascertain what circumstances might amount to wholly exceptional. But if, for instance, it was possible to contend that the existence of the claim debt was so clear-cut that it was incapable of serious dispute, if that was an exceptional circumstance, that would effectively open the back door to an argument on the merits, which is precisely what the Court of Appeal said it was trying to avoid. And those questions were very recently considered by the Court of Appeal in Singapore in the case Anam Group and VTB Bank. The facts were that there was an agreement between the parties that provided for the bank to purchase the appellant's shares. Those shares would then be sold back to the appellant at a price to be calculated according to some pre-agreed formula. So the agreement really, despite the way it was dressed up, was in substance a loan. And the loan was subject to an arbitration clause, and the bank petitioned to wind the borrower up. And various bases for disputing the debt were put forward, but most importantly, the borrower relied upon the arbitration clause. And at first instance, the judge wound the company up, holding that the test was the substantial dispute standard of review, which Alex already referred to. The Singapore Court of Appeal came down on the other side of the debate, saying that the right test was a prima facie standard of review, so that the debtor had only to show A, that there was a valid arbitration agreement, and B, that the dispute fell within the jurisdiction, within the terms of the arbitration clause. And the Court of Appeal also held the same test should apply both to a disputed winding up petition, but also to a winding up petition that was disputed on the basis of a cross claim. And having reviewed the authorities in all number of different jurisdictions, the Court of Appeal supported its conclusion on the issue by referring to a number of grounds. Firstly, the Court of Appeal said that was a result that was coherent in terms of the law. It prevented the use of winding up as a pressure tactic to bring the merits of the case into court. And it also applied the same test as is applied where any other proceedings are started contrary to an arbitration agreement. Secondly, it supported the idea of party autonomy, notwithstanding the fact that there was insolvency in the background with all of this. Nonetheless, the parties should be held to their agreed dispute resolution procedure. And thirdly, and perhaps more controversially, the Singapore Court of Appeal said that the result gave certainty, but it also gave savings. And it might be said that those savings are somewhat open to debate, because in reality, what the test requires, by applying the prima facie test and forcing the issue to go to arbitration, you're requiring a party, a debtor company, which is already potentially close to insolvency, to expend substantial sums for arbitration proceedings. But where the Court of Appeal in Singapore perhaps developed the law a little more was in respect of the residual jurisdiction. The Court of Appeal in Salford Estates had been unable to find any examples of the exceptional circumstances. The overall approach of the Singapore Court of Appeal was to tone down the wholly exceptional test, which it said was pitched extremely high, and say that the exceptional circumstances would generally be those which amounted to an abuse of process. So the examples that the Court of Appeal gave was where a debtor disputes a debt which has previously been admitted, or where the company in question has waived any right to refer to arbitration, or where they say where the debtor company is seeking to stave off substantiated concerns which justify the invocation of the insolvency regime. Now, that demonstrates the thin line, I think, that lies between deciding not to examine the merits of a case and applying abuse of process test, because obviously when you're deciding whether or not a company is staving off insolvency proceedings, it requires you, to a certain extent, it might require you to look at the merits of the underlying case. And obviously that's something which the Court of Appeal in Salford said shouldn't happen. And that really brings me to the third of the cases to which I'm going to refer, which is a very brief case report in Telnick and Nip, which we have to treat with some caution because we don't actually have the Chancellor's judgment in granting permission to appeal. But it's an interesting case because at first instance, the deputy judge stayed the winding up proceedings on the basis that the dispute was subject to an arbitration agreement in the usual way. And the creditor was ordered to pay costs into an escrow account. Nonetheless, the debtor company appealed, saying that the petition should have been struck out and the cost should have been paid to it on the indemnity basis. And the petitioner cross-appealed on the basis that the judge was wrong to hold that there were no special or exceptional circumstances requiring the court to decide whether or not the petition debt was disputed on substantial grounds. And the petitioner argued that the three exceptional circumstances were that the debtor was insolvent irrespective of the petition debt, that the debtor had applied unsuccessfully to stay the arbitration proceedings, and that the debtor had not engaged properly, it said, in the arbitration, whatever that might mean. And applying the prima facie test, one would have thought the petition should simply have been dismissed. However, the Chancellor granted permission, and the case report says that it was held that Salford Estates did not establish that a court could not inquire into whether a debt that was subject to arbitration proceedings was disputed in good faith or on substantial grounds. It was, to quote, a matter of discretion. Now, if that's right, that's surprising and potentially a significant development in the law. The other case we've referred to in the slide, Field, Fisher and Pennyfeathers, really that's just an instance of the application of the prima facie test to arbitration proceedings in a case where really the grounds for disputing the debt were, to say the least, incredibly thin, but nonetheless the judge felt without enthusiasm he was constrained to give effect to the arbitration clause. That's probably enough from me at the moment. In the next slide, we're going to look at the position post-liquidation or in administration, and Lexa's going to do that.
So this situation is where an arbitration is already in progress, but one of the parties goes into an insolvency process. Should the arbitration continue? And what's the relevant law for determining that question? In Guernsey, when you have an administration, you have an automatic stay, same as in England. Where you have a compulsory winding up in England, there is an automatic stay. My understanding is that in Guernsey, there's a discretionary stay after an application for winding up, just as there's a discretion to impose a stay in a voluntary winding up in England. Against that, you have the Arbitration Guernsey Law 2016 and the Arbitration Act 1996 in the UK. Both acts provide that where you have an arbitration agreement and one party decides to litigate effectively in breach of the arbitration agreement, i.e. not referring the dispute to arbitration, then the other parties can apply to court for a stay of those proceedings, and a stay is mandatory unless the court satisfied that the arbitration agreement is null and void, inoperative or incapable of being performed. So what happens when a company goes into, say, for the sake of argument, administration? There is an automatic stay. So how does that square with the idea that there's a more or less automatic stay when you have an arbitration agreement? Well, it's not an area that's come up that frequently. If you can just move on to the next slide now, we'll discuss the case of H&CS Holdings and Glencore International AG, which was reported in 2019. That case, in fact, followed on from a much earlier case, which was called Costco Bulk Carrier Company Limited and Armada Shipping, which was decided by Mr. Justice Briggs in 2011. But the recent case of H&CS Holdings draws on Costco Bulk Carrier, so it's worth looking at that case for the latest learning on the matter. What happened in that case is that H&CS was a Singapore company that was in liquidation in Singapore. And at the time it went into liquidation, there was an arbitration in progress in London between H&CS Holdings, the company that went into liquidation, and Glencore. And the office holder of the H&CS Holdings in Singapore trotted across to the UK and asked for the appointment and the proceedings in Singapore to be recognised under the Arbitral model law on cross-border insolvency. And the court in the UK was very willing to recognise the foreign proceedings under the model law. I mean, it's basically a tick box exercise. There's no discretion in the matter at all. And therefore, the effect of that, and really the purpose of the office holder trotting across to the UK, was to get a stay, the automatic stay that is imposed upon recognition. And therefore, what the office holder was intending to do, and its purpose in doing it, was getting a stay of all proceedings in the UK, including the extant arbitration proceedings, all well and good, but immediately after the stay was imposed, the automatic stay under the model's laws it imposed, Glencore applied to lift the stay so that the arbitration proceedings could continue. And the judge held that, yes, the arbitration proceedings could continue because, having looked at all the facts, the judge concluded that it was in the interests of the insolvency proceedings to do so. One issue that really hasn't been explored at all in the UK, as far as I'm aware, not in any other of the jurisdictions that I'm familiar with, is the question of whether, if you have an arbitration agreement in a liquidation, a liquidator would be entitled to disclaim the arbitration agreement. And the reason why I say that is because in sort of arbitral jurisprudence, an arbitration agreement is always considered as a separate agreement to the underlying agreement. And it seems to me that, in principle, a liquidator could, particularly if the arbitration proceedings were very expensive, and he took the view that the proof procedure, for example, would be cheaper and easier, seek to disclaim the arbitration agreement and get rid of it that way. Having said that, my view is that certainly in England and Wales, the judges are so enamoured of arbitration, and my theory is that they all want to be arbitrators when they retire, and that's why they're so enamoured. But they're so enamoured of arbitration proceedings that if a liquidator, certainly in the present climate, were to seek to disclaim an arbitration agreement, he wouldn't be permitted to do so, because it would be inconsistent with the overwhelming policy at the moment in the UK, which is to favour arbitration proceedings over almost anything else. So that's all I wanted to say about the situation sort of post-liquidation when arbitration proceedings are in existence. If we can move on to stage 3 now, which Dan is going to address you on. We can keep the slides as they are, because the slide deals with stage 3.
So there's a bit of a theme emerging here, which is that the arbitration agreement always wins. And that trend really carries on in respect of a claim subject to an arbitration agreement which is to be commenced after the insolvency procedure has begun. There are 2 cases I'm going to look at very briefly. The first of those is Philpott and Lycée Française, where the liquidators of a construction company applied for directions in relation to a proof of debt. And this was a claim under a construction contract that was subject to an arbitration clause. What the liquidators said, and it makes some sense, is that there should be an account under the insolvency set-off provisions of the claims going each way, and a total amount decided upon, whereupon they could adjudicate upon the debt. And if the creditor was in any way dissatisfied, the creditor could appeal that decision. And the construction company, on the other hand, said that the arbitration agreement applied and there should be an automatic stay under Section 9. And they also, and that stay should also be applied to the liquidator's application for directions, just as it would apply to any appeal procedure or adjudication on the debt. And the court agreed in that case, and once again said that the liquidators were bound contractually to go off to arbitration. And they also said, the court also said that by proving its debt, the creditor didn't, the creditor didn't compromise its right to bring the arbitration proceedings. The mere submission of a proof of debt didn't constitute taking a step in the proceedings in answer to the substantive claim. So if there is an arbitration agreement, it applies notwithstanding the fact that there's a liquidation. And that brings us really right up to date with the freshest possible law from the Supreme Court in the case of Bresco, which was a dispute in relation to another construction contract, which, as usual in those cases, contained an adjudication clause. And the creditor subcontractor appealed against the decision to restrain presentation of a winding up petition by it on the basis that any dispute was subject to adjudication. The debtor cross-appealed the decision that adjudication applied. And the Supreme Court held that a main plank in the Court of Appeal's reasoning regarding jurisdiction was that if a liquidator was entitled to pursue the insolvent company's claims by arbitration, then the same had to apply to the right to refer disputes to adjudication, and that was right. There was no reason why the 2 forms of dispute resolution should have been treated differently, and therefore the cross-appeal on jurisdiction failed. The parties were bound to go down the adjudication route, regardless of arguments about insolvency set-off. So the overall theme, again, even in stage 3, post-liquidation, is that the parties are bound to arbitrate if that's what had been agreed, unless, of course, they agree to the contrary. And there may be reasons why a creditor would agree to the contrary if the debtor company is unlikely to pay its share of the arbitration costs, for example, in which case the creditor company will be bound to pay those arbitration costs for it. Lexa, you're going to say a little bit about Norrie Holdings, I think, at the end.
Yes, I'd say that in my experience, what I found is that generally the company in liquidation doesn't want to arbitrate. It's the creditor that wants to arbitrate, not least because the creditor hopes that the company in liquidation won't participate that aggressively in the liquidation, and they'll get a huge arbitration award that they perhaps wouldn't have been able to get if the company in liquidation was better resourced. Now, the final case I want to talk about is this case of Norrie Holdings Limited, which rather illustrates the point. There were insolvency proceedings in relation to a company in Russia. What happened was that a creditor commenced arbitration proceedings. The agreement was subject to an arbitration agreement, and commenced, sorry, my mistake. So the insolvency officer in Russia commenced proceedings in the Russian court, seeking the kind of relief that one would obtain in the UK and in Guernsey as well, arising out of a transaction to undervalue. And what happened was that the defendant commenced arbitration proceedings in the UK, and also made an application in England under Section 37 of the Supreme Court Act to stay the proceedings that were taking place in Russia, alleging that the creditor was party to a transaction at an undervalue. And the court granted that injunction. The interesting point about the case was that it was argued that transactions at an undervalue wasn't within the scope of the arbitration agreement because it was essentially an insolvency claim. But the English court concluded, having looked at the width of the arbitration agreement and the clause, the arbitration clause, that in fact it was covered by the arbitration clause. So you've got this interesting concept, which we really haven't had in the UK thus far, where you could have an arbitration agreement and either the liquidator or a creditor arguing that what we would call a clawback claim should be determined pursuant to the confidential private arbitration agreement, and other creditors who might have a valid interest in what happens in those proceedings will never get to know what happens. So quite an interesting area to keep an eye on there. Well, I think we've exhausted our time. There's a question and answer at the bottom. Shall I just click it up?
Yes, I'll answer it live, Lexa.
Oh, right.
There you go.
What if a liquidator enters into a new contract that contains an arbitration clause? How might that impact with Rule 1242? Well, and the requirement for detailed assessment on the request of the committee. You're absolutely right. The question is hypothetical, but I've thought about it myself. And it's obviously not an area that's being considered judicially, and I find it quite problematic for the reason that I mentioned towards right at the end of the talk. But arbitration is generally, it's a confidential process, it's private, and one needs to contrast it with what is said time and time again by the courts, although not in relation to petitions presented when there is an arbitration clause. But generally the courts say that, insolvency is a class remedy. Well, if it's a class remedy, you ought to have access to what is going on and have some accountability by the liquidator in relation to proceedings that are being taken for your benefit. But if the matter is subject to arbitration, that's pretty difficult. I don't know what Dan has to say. If Dan's got anything to say about it.
I noticed the questioner was Steve Hunt, so I knew it was going to be a question that would be incredibly difficult. I was going to say what I always say when I get asked questions like this by Steve, which is I need to go away and research it, because I'm really not convinced how you answer that at all, actually.
Well, can I make that an open invitation to anyone else who has any other potentially rather tricky questions that they didn't want to air on the Q&A? Please do email any of us or all of us with any questions that you have coming out of the two talks today. Although I didn't want to cut Daniel off there. I don't know if he had something, he was only partway through his thought.
No, I'll email Steve separately about that very difficult question.
Well, that sort of fits in some ways quite well. You can have your own, much like private arbitration, you can have your own private question session, and none of the other interested parties can see what may have been asked or what the answers were, in a sort of fitting metaphor. And with that, I think it just leaves me to say thank you to Lexa and to Daniel and to Claire, and of course, most of all, thank you to all of you for joining us today. As I said, we are hosting another webinar, a different panel. That will have more of a trusts focus, although with the twist that we will be comparing, on the one hand, the duties that a trustee owes to the court when making a blessing application, and the duties that any, say, commercial party in commercial proceedings owes to the court when making an ex parte application, such as a freezer. And Terry Marchents and Bobby Friedman will be taking you through the latter position first on ex parte commercial applications as hopefully an illuminating point of comparison to what Jonathan Hilliard and Simon Atkinson will then say on trustee blessing applications. And with that, it just leaves us to say thank you all for joining us, and I hope you stay safe and well. We look forward to seeing you soon, and have a good afternoon. Goodbye.